All right, hey guys, a lot of people are asking me, Abe, there's this law that I heard of. It's called a proposal for settlement law. And I heard that you can get attorney's fees on the PIP cases under the proposal for settlement law. So nothing's really changed. And so I disagree. I've done work on diminished value cases where I've filed a lawsuit. I've sent a proposal for settlement. At the end of the day, you still need to get, quote, a judgment on that case. You need to win that case. You can't just, oh, we got you, pay us fees. It doesn't work like that. You need to get a judgment, summary judgment hearing, or a trial. If there's issues of fact, you would go to a trial. If it's just a purely legal issue, you could try to get a summary judgment heard on that matter. So the way it would work, and I'm just reading from my email here, is the proposal for settlement law only awards attorney's fees after you make a written offer 90 days after a lawsuit is served. So basically, Abe would send a demand letter. The insurance company doesn't pay. Let's say they owe $1,000, okay? $1,000 in this scenario. And let's say I file a lawsuit for the $1,000 that the doctors owed. That's the legitimate number they're owed with the fee schedule calculated, blah, blah, blah. File a lawsuit, wait 90 days. Then I would have to file this document. It's called a notice of filing a proposal for settlement. And I would send the proposal for settlement for a certain amount. Now, remember, you have to beat the proposal for settlement by 25%. So let's say a doctor is owed $1,000. That's the max that they're owed, right? I would have to file a proposal for settlement for a number that I know I could win. I'm not going to file a proposal for settlement for $1,000 because I have to beat it by at least 25%. So if I have to beat it, that means, okay, so on a $1,000 case, I would want to file a proposal for settlement of, let's say, $500 because I want to win by 25% the case, which would mean I would need to get $625, right? That's 25% on top of the 500 is 625 total. So an extra $125, okay, is the 25%. So I know this sounds crazy and confusing, but the doctor's owed $1,000 when you calculate the fee schedule. I'm going to file a proposal for settlement for $500 on the 91st day, okay? And then I'm going to have to go 2 years, 3 years into the case. I'm going to have to either win a summary judgment hearing or go to trial. That takes a lot of time. It's very time consuming. Most PIP suits right now, they settle because there's automatic attorney's fees for the prevailing party. And in the PFS case, I've done this before with diminished value cases. They don't just say, oh, well, you know what? You're going to win this case, so we'll just give you attorney's fees. They make you run through all the hoops. They make you go through the hoops of winning to get your judgment. And so remember, if there's a proposal for settlement, the goal is not to be the prevailing party to win. The goal is to make an offer, hope that the insurance company doesn't accept the offer, okay? Because they have 30 days to accept or reject the offer. After 30 days, it's automatically rejected. So you're looking, let's say you file a lawsuit. It takes 30 days to get served. Then you have 90 days to do your proposal for settlement. You got to wait. Then on the 91st day, you file a proposal for settlement. That clock doesn't start ticking until that 91st day. So the filing of the lawsuit, all the hearings that you had to do in those first 90 days, like a pretrial hearing, if discovery's done before then, which it usually isn't, none of that's reimbursable. The clock for attorney's fees starts on day 91, okay? It reverts back to that date, 30 days to accept or reject. What happens if the lawyer goes through all that work, file the lawsuit, serve the lawsuit within 30 days, file the proposal for settlement right away on the 91st day of service, goes through all that work, and then the insurance company says, yeah, we'll accept the $500. Here's a check for $500. Leave us alone. Okay, it costs $100 to file that lawsuit, maybe more. Okay, let's just say it costs $100 to file that lawsuit. So the lawyer is going to say, all right, they sent a check for $500. They're going to cut the first $100 back to themselves, and they're going to keep a percentage of whatever they collected. So they're going to take, first of all, they're going to take 40%, let's say that's what they're charging. I don't know what the lawyer would charge. I haven't figured out what I would charge yet under this scenario. Remember, this is just for policies issued on 3/25, March 25th, March 26th, that direction. So let's say the lawyer's charging 40%. They send an offer for $500 and it gets accepted. The insurance company is going to cut a check for $500. The lawyer is going to keep 40% of the $500. Then they're going to take back their extra $100. Okay, the $100 doesn't come off the $5. They take the 40% first, then they take the $100. What's the doctor going to do with an extra $200 or something like that? $150. Is it worth it? Now, let's say for instance, the insurance company blows the 30-day deadline and doesn't pay the proposal for settlement. They could simply confess judgment on the $1,000 that might be owed, and it's just not enough money for the lawyer to continue long-term this kind of work. Let's say the insurance company fights tooth and nail. The plaintiff's lawyer goes all the way to a summary judgment hearing or to a trial. Keep in mind that the insurance company files their own proposal for settlement. So if they file a proposal for settlement and they win, they beat their proposal for settlement by 25%, the doctor's office might have to pay legal fees on that case. Is it worth it on a $1,000 case? I don't think so, personally. Just letting you guys know about this so you can talk about it and think about it. It's a question that I get. And just to reiterate, you kind of need everything perfectly aligned. You need to file the proposal for settlement on the 91st day of service. You need to hope that the insurance company doesn't pay the proposal for settlement offer right away. Because remember, if you're owed $1,000, you're not getting the $1,000. The lawyer would file a proposal for settlement for an amount where they feel they can win, guarantee a win, because they're really after the attorney's fees, and that under this scenario, they're just hoping to get attorney's fees, okay? They're not hoping to get the doctor every single penny they're owed, because that's out. That's under the old law for policies issued on March 24th, March 23rd, that way, okay? So you need a perfect alignment. I know this is funny pun for chiropractors. You need everything to be perfectly aligned. The insurance company doesn't pay within 30 days. They could still, after the 30 days, they could confess judgment shortly after that and only be on the hook for the fees from the date the proposal for settlement was filed to that date if they wanted to confess judgment on those cases. So again, I don't think this is a realistic, I've heard some PIP lawyers, we're just going to file a proposal for settlement on every case. I disagree. I don't think that's going to really happen. I think on a certain case, it makes sense. Let's say there's a clear-cut, very obvious situation where the insurance company, let's say the insurance company hired an IME doctor. He did hundreds of IMEs, and let's say that something bad happened to that chiropractor. It was found out that they didn't have a license at the time they signed the IME letter, cutoff letter. Okay, and then you sue the insurance company, you file your proposal for settlement, and after that expiration, they realize, oh my gosh, the IME doctor didn't have his license on the day that he signed hundreds of IMEs for us. We're going to lose all these cases. This is going to be bad news. This is embarrassing for us that we would even not realize the chiropractor who did the IME cutoffs didn't have a license. Slam dunk case, they're going to win. Maybe in that situation, it makes sense, but I don't think it makes sense in most situations. Remember, the PIP lawyer is going to still have to win the case at a judgment. They're not just going to pay attorney's fees. I've done that work before, and it hasn't really panned out. So thanks for watching on that.